Okay, good morning, everyone. I guess I'm the host of this for today. For all that don't know me, I'm Steve Brower. I am the broker in charge for Coldwell Banker Advantage, the Chapel Hill office. I think I have an OCHAR title too, but I don't remember what it is today. But we're not here for me. We're here for Dee Bigelow. She just waved. Dee is. I like that. What they had was Ms. Bigelow. I'm just going to call you Dee. Dee is the information officer for the North Carolina Real Estate Commission. Originally from Onslow County, Dee grew up as a Marine Corps dependent. She began her career with National Semiconductor in San Diego. Not sure why she left there, but has lived in North and South Carolina, Northern Virginia, New Jersey. I know why she left there. Panama, Michigan, Mississippi, Louisiana, Ohio, and Arizona. There you go. Dee attained her real estate broker's license in 2005 and spent several years in sales before transitioning into administrative roles. Dee has also worked for several law firms as a real estate paralegal, as well as processor for estates and tax foreclosures. She spent the past 5 years as the office administrator for Berkshire Hathaway Home Services, Yost and Little Realty, always the longest company names, in Greensboro, before joining the North Carolina Real Estate Commission as an information officer in September of 2020. As an information officer, Dee answers questions about North Carolina real estate license law, commission rules from brokers, attorneys, and the public. And today, Dee's going to keep us off the back page, correct?
I'm going to do my best. Give you information that will keep you from getting on that back page. So let me see if I can get the screen share going. Bear with me. Excuse me. Okay. There we go. How to stay off the back of the bulletin. How do you get on the back of the bulletin to begin with? You receive a complaint. So avoiding complaints keeps you off the back of the bulletin. In 2020 and 2021, we are going to be processing approximately 2,000 complaints this year. 5 to 10% of those will result in disciplinary action, and about 90 to 95% of them will be closed with no action, and about half will get a cautionary letter. In all honesty, I mean, we really work to help you be better agents rather than take your license away. So if we can do anything, is whatever we can do to help that be the end result, is really what the aim is. Some of our top complaints, the biggest one is property management trust account issues, tenant security deposits, mismanagement, that type of thing. Those are the bulk of our issues that we have. Offer and acceptance, which I'm getting a lot of calls on with the multiple offer situation. Earnest money deposits and due diligence fees, due diligence repair requests and agreements, misrepresentation and omission of material facts, whether that be willful or negligent, agency issues, providing the working with real estate agents brochure, dual agency for sale by owner, that type of thing, self-dealing and conflicts of interest, drafting legal documents, lack of communication, broker competency, and more. Complaint resolutions. Most complaints can be avoided with better communication or an apology on the broker's part. That's one easy, quick way to start to keep off that back of that bulletin. The commission favorably considers any efforts by a broker to settle differences with their clients and their customers. Once a complaint is filed, however, it becomes part of the public record, the permanent record, and it cannot be withdrawn. It can't be deleted or removed from the system. It's there forever. Top complaint topics. Offer and acceptance. We've got a deal. How many of y'all have heard we've got a deal? Well, and you don't have a deal if the offer is not in writing, if it has not been signed by all parties and communicated as having been signed. Please do not ever use the term verbally accepted. It is not a contract till the seller signs it, and that is communicated back to the other party. I think the best thing to do is just to tell the buyer that the seller's looking at their offer in the most favorable light, and as soon as it's been signed, you will let them know. Any oral offers or acceptances can't become binding contracts. They have to be reduced into writing. And we have many good resources on our website under the publications tab. There is a Q&A on offer and acceptance. It's a brochure that is a great tool to have available for your clients so they can understand this process, especially now with all the multiple offer situations. I think this is probably something everyone should have available. You can download a PDF and give that to your client or email it to them. As far as multiple offers goes, if you have permission from your seller, you can disclose to the other parties that there's more than one offer. Your seller must say that that's okay to disclose. And if you disclose it to one buyer, you have to disclose it to all. So you have to be fair and equal in the disclosure once the seller says you can do so. Once again, can't disclose the existence of multiple offers without the seller's approval. If you disclose to one, you must disclose to all. I'm getting a lot of calls about escalation clauses, and we probably will be getting complaints about them as we go down the road. They are not illegal. There is no NC Realtor escalation clause form. Probably will never be one because licensees are not allowed to disclose the terms of a buyer's offer without that buyer's express written permission. And good luck getting a buyer to give you something that lets another buyer get the deal over them. So it's usually not going to happen. When you're working with multiple offers, you need to be careful to avoid self-dealing and conflicts of interest, which means if you have an interest in purchasing the property, you should probably get your broker in charge or another agent to assist on one side or the other so that there is no, there's less of a likelihood that it looks like you're doing things for your benefit and over other buyers. The offer to purchase and contract. I have not sold a house in 10 years, and I know that offer to purchase and contract up one side and down the other, inside and outside. I can give you paragraph references for different stuff just off the top of my head. You should be able to do the same when you're dealing with clients. You should read it. You should know it. It's the foundation of all your deals. It's basically the Bible, and it dictates, you know, what each party's responsibilities and rights are. And the more familiar you are with it, the more you familiarize your clients with it, the fewer issues that you will have, the fewer misunderstandings you're going to have. And so I highly recommend that if you aren't thoroughly familiar with all of the ins and outs of that offer to purchase, that you should do everything in your power to do so. Earnest money and due diligence fees. We get a lot of complaints about, especially recently, about due diligence money. Section 1D of the offer to purchase and contract indicates that the due diligence fee is to be delivered to the seller by the effective date of the contract. And then you get a choice. You can, for the earnest money, you can check the box where you give it with the contract or within 5 days of the effective date. You should always check one of those boxes because that opens up a lot of confusion if it's left blank as far as when earnest money is due. The effective date of the contract is, of course, the date on which the last party has signed that offer to purchase. And the best practice is to collect those checks when the offer is written and have them in your possession for delivery once the seller has signed and that has been communicated back to the buyer. Photos of checks are not negotiable. However, if you wish to send along a photo or a copy of the check with your offer to show that you do have it in your possession, that's fine. But you should actually have them before you do that to indicate that the buyer has written them. Cold feet. I get a lot of calls about this. I get agents saying, you know, we had a buyer who made the offer, did not deliver due diligence money. Now they want to terminate. They've never given us due diligence. Did we have a contract? What do we do to get the due diligence fund money from the buyer? Well, you do have a contract. A contract is a contract once it's signed. If a due diligence check is not delivered, the buyer's only recourse is to accept that termination and then go through the legal channels in order to get the buyer to pay the money that they owe contractually. Should they choose to do that, that's really their only option. We can't enforce or force a buyer to produce a due diligence check, but they still have the option to terminate that contract unilaterally during due diligence period. Once again, the timeline for due diligence. The fee is due at the effective date of the contract. It is still a contract if the money has not been received. If the money is not provided, the seller has the option to make a one-day demand, and there is a form, I think it's 355T from NC Realtors, wherein the seller can let the buyer know, I need the money in readily available funds within one banking day. And if they do not receive it, then the seller has the option to terminate unilaterally at that point. Due diligence fees are not refundable. They're not refundable. They're not refundable. They're not refundable if a seller has not disclosed a material fact. They're not refundable if a seller won't make a repair. The only instance in which a due diligence fee would be refundable would be if a seller breached the contract. All of the terms that the seller are and their responsibilities that a seller has is in paragraph 8 of that offer to purchase, none of which are non-disclosure of material fact. And then 8N addresses the fact that if a seller breaches per any of the other terms on paragraph 8, that the buyer would then be entitled to a refund of their due diligence money, a return of the earnest money, and a return of any costs or reimbursement of costs that they had expended in order to move forward with the sale. Otherwise, if they can't agree on repairs, or the buyer has an issue with their loan, or an appraisal comes in low, or any of those things, that's not breach. The buyer's not entitled to a refund of their due diligence money. All inspections, appraisals, repair requests, and amendment requests should be performed, negotiated, and agreed to prior to the end of the due diligence period. So everything by the 5 o'clock on the due diligence date, everything should have been done, discussed, agreed upon, reduced to writing. Buyer should be ready to move forward at 5:01 on due diligence date. So the seller doesn't have to perform any repairs. They just have to have an agreement in place as to what they're going to be doing. And once all that's done, then move forward, and you should have a reasonable expectation of closing at 5:01 on the end of due diligence. And there is a line in the sand, and that is it, that due diligence date. If a buyer terminates prior to the end of due diligence, the earnest money is on the buyer's side of the contract and would go to the buyer. And at 5:01 at the end of due diligence, it shifts over to the seller's side. So if a buyer and a seller have not come to an agreement and buyer does not terminate prior to 5 p.m., that money has shifted over to the seller side of the transaction per the contract. And I would venture a guess is that would be enforceable in a court if everything has been done properly and there's no question. So a judge is probably going to say once due diligence ends, contract says it belongs to the seller. So the next question, due diligence, repairs and requests. The complaint is they didn't get it fixed, they didn't fix it, they didn't address it appropriately. So you have a vague due diligence request that it refers back to inspection numbers, and they don't really ask specifically for how something should be addressed. It's just take care of this thing on the report, and they're vague and not specific. And who should interpret that? The sellers interpret that, and then the buyer comes back later on and says it wasn't fixed. So as a buyer's agent, you should be very specific about what you are asking, discuss it with your buyer, request a specific repair performance, such as, you want a licensed contractor to make a repair, or you want, however that wants to be addressed, you should be specific. So being specific, you can use more than one due diligence request and agreement during due diligence period. You're not limited to one request. So if you have an inspection done that uncovers one thing, and then they go back and maybe have an HVAC person come in to do a specific inspection for that, you can do another repair request as many times, as much as you need during your due diligence period, and all that can be negotiated. I highly recommend that part of what you include in your due diligence request is an option for the buyer to go back in and double check and make sure the repairs were done to their satisfaction. And you should not wait till the day before closing to do that. You can ask the seller to provide invoices for work that was done, and you can schedule a time to go back in with your buyer, check to make sure everything was done. And if not, get it addressed early enough so you're not walk through an hour before closing and realize that something wasn't done properly. So you should be thorough in all of that. I see there's questions in the chat. So we'll be addressing those towards the end. Another common complaint that we get is material fact issues. They didn't tell me about ... A licensee has a duty to discover and disclose material facts about a property they are listing. A material fact is any information that could affect a reasonable person's decision to buy, sell, or lease a property. We have a lot of good material on our publications. Again, if you go in, click on the publications tab and enter material facts into the search bar, you will get some really good information there. We have continuing education classes that have specifics in there about like polybutylene pipes and flooding and death of a resident or something like that. All that is addressed, and it's very, very helpful information to have. Material facts can be facts about the property itself, facts affecting the property, facts about a principal's ability to perform, and facts known to be of special importance to a particular buyer. If you have a buyer who wants to have chickens and you're looking at properties that are in a subdivision and in the main city, you're probably not going to have chickens in that for that buyer. So you need to know that if they say, I'm specifically looking for X, Y, and Z, they want to have a beauty salon, they want to run a business, they want to have chickens, they want to do something, specific with that home, you need to do a little bit more homework and make sure that they were able to do that with the house that they're putting an offer to purchase on and investing money in. Or it might end up on the back of the bulletin. And once again, it is an agent's responsibility to discover and to disclose material facts. If you know or reasonably should know that there's an issue, it needs to be disclosed. You should be asking questions, verifying information. One of the things I saw when I was at Berkshire Hathaway was we had someone come in to talk about underground storage tanks, and he talked about when you walk in the yard of a property, there are certain things that you see that might be red flags, such as a pipe sticking up out of the ground or coming up and attached to the house. So that may be a red flag. So if you see something that makes you go, what's that? You should be asking, what's that? There's a big crack in the floor in the basement. What's that? Are you familiar with, an issue with that? Ask it, you need to be asking. So that part of that is making that visual inspection, looking for things that are unusual and asking questions if possible, doing a search also of your public records. If you have a house with a septic tank, you should be pulling that septic permit and checking the number of bedrooms that are on the septic permit. And existence of a septic is a material fact that must be disclosed. You may only list the number of bedrooms maximum that are on that septic permit. So that is a public record thing that you can locate. Another thing regarding public records is you can look up on a register of deeds, the deeds, any deeds of trust. If someone calls you and says, I want to list this house for sale, you should be pulling that deed right off the bat and make sure that the person you're speaking to has has some ownership interest in that house. If Mary Smith calls you to sell her house and you pull the deed and the deed said it belongs to Joe Jones, well, you better be asking Mary Smith why she thinks where her authority is to transfer that title. Solve a lot of problems before you ever get to dealing with a buyer. We recommend that you absolutely do not rely on information previously gathered, which means don't pull an old listing. If someone else listed it in your firm and they had square footage, don't go by that. Go out and measure it, or have your reliable appraiser person that you hire to measure homes do that for you. You should always just double check anything that is on a tax card. A good thing to have when you go out to measure a house is the footprint from the tax office. A footprint will show you pretty clearly and pretty quickly if you may have some unpermitted space that you're dealing with. And your only duty, if you do have unpermitted space, is to disclose that. It's not your job necessarily to remedy the situation, but it is your duty to disclose. If you've got a space that was like a basement space that was finished but not permitted, or a bathroom or something like that. Disclaimers may not be a defense, just FYI. So our next top complaint topic is misrepresentation versus omission of material facts or information about the property. The biggest misrepresentation issue that we generally deal with is heated square footage. It was, like I said, taken from maybe a tax card or from a previous listing, but wasn't actually measured out by the agent. If something is misrepresented, the agent is responsible for that. We at the Real Estate Commission do not require you to measure a home. However, if you are going to put something in a multiple listing system or service that asks you to represent the square footage of that home, it should be accurate. So that's where we come in. We're like, if you're going to put it out there and it's inaccurate, we're going to take a look at that. And omission, of course, is not including something that should have been included, such as maybe possibly the existence of a septic permit, or that there is a septic and not, just assuming that it's on public utilities. Some of these older neighborhoods that are like in cities that are generally on public utilities may have a septic system. And so that's always a question to ask, especially if it's an older neighborhood that's like over like 50 or 60 years old. And then we get into the situation whether these misrepresentations or omissions are willful or negligent. If, of course, if you know a material fact about a property and you willfully omit disclosing that, or you willfully misrepresent something, that's going to have a higher penalty for you than just, you know, being negligent, not understanding or knowing that that was something that you needed to disclose. And we have all levels of, you know, differentiation as far as whether, you know, something is a material fact. We do leave a lot of it up to your interpretation as the agent to whether it rises to the level of material fact. We give you good information about how to determine that. But if you choose to not disclose something and we get a complaint, we're going to be questioning how you made that determination. So if there turns out to be some intent on your part to conceal or misrepresent something, that's going to be an issue. Most likely you'll be on the back of the bulletin. Some material facts include things like square footage, whether or not there's a septic permit, any improvements to the property and permits for those, any major repairs. However, if you have a fire or something like that, and it has been completely renovated and returned to its pristine original condition, that does not necessarily have to be disclosed. If someone asks you specifically, you need to be honest, but if it's been repaired to its original condition, that's not necessarily a material fact. Flooding might be, because that could recur. Water and sewer situation, if there was ever issues with the water, like a well that was contaminated or something like that, or sewer line issues, those things are material facts. Title issues are material facts, whether the home is in a flood zone or not. If there are any restrictive covenants and any future changes, such as roadways that are coming in or nearby construction for new subdivisions or housing or that type of thing, may end up turning into things that you misdisclose as material fact. All right. Our next topic is agency, but I thought they were my agent. The Working with Real Estate Agents brochure is to be provided at first substantial contact and reviewed with the customer that you are meeting with. You should have a real conversation about how they are to understand how agency works in the state of North Carolina, not just put a link in your email and think that suffices. And I always recommend that you find a narrative that works for you. What worked for me when I was doing sales and what I trained my agents on at Berkshire Hathaway was to use an analogy like an attorney. If I'm going to sue someone, I'm going to hire an attorney, and that attorney is going to be my representative, and my representative is going to work to find out as much information about the other party as possible so that I get the most benefit out of this lawsuit arrangement. And so whatever they can dig up that's going to be to my benefit, then as my representative, they can do that and share that information with me and help me leverage that to my benefit. So that is straight up exclusive agency. Dual agency puts you in a position of being basically now a mediator, wherein you cannot lean in one direction or the other for either party. You are to basically lay out the rules of the game. You can provide statistical information to them, but you cannot advise one party to the detriment of the other party. You must remain neutral. You cannot disclose anything about the other party's motivations or their financial situation or anything like that. And then designated agency sort of returns you back to your respective corners, but you are still required to maintain that confidentiality and not disclose the motivation or any personal or financial information about the party on the other side of the transaction. And I've had several calls recently about when you check that sub-agency box. If you're going out and you're doing an open house for an agent in your office and you're working with real estate agent brochures, and buyer comes in and starts talking to you and saying, oh, I really like this house, but I'm looking for this price range and this money. That's your first substantial contact. Until that buyer signs an agency agreement with you to represent them, whether in a dual agent capacity or exclusive agent capacity, you are a sub-agent of the seller and you check that box. So up and until you have an agency agreement, you're a sub-agent of the seller. As far as agency agreements, before you act or have an agency agreement executed, you need to have a clear understanding of what services you're providing as a broker and what services the consumer is expecting. So those details should be spelled out completely and in writing. And that's what the buyer's agency agreements are that the NC Realtors provides in the listing agreement. So you should be familiar with them so you can help them understand. A buyer's agent, when you sign a buyer's agency agreement with with the client, they are agreeing to pay your commission. The NC Realtors buyer's agency agreement says the buyer's on the hook to pay that commission. However, it also says that you will make every effort to get the seller to pay it. But if the seller does not pay it, then the buyer is on the hook for it. I get a lot of calls about agents wanting to know why the seller's not paying their commission when a deal fell through, because the seller's agreement is with the listing agent to pay the listing agent, not the buyer's agent. The agreement says if the listing agent receives payment from a seller, then they will share that with the buyer's agent, but it doesn't obligate them to pay the buyer's agent directly. That agency agreement with the buyer obligates the buyer to do that. So if you have an issue with whether or not a buyer's paying your whether you're getting commission fall through, that would be a question that would need, a conversation needs to take place between you and your buyer. Fiduciary duties that are you're required under an agency agreement are loyalty and obedience, accounting, disclosure of information, and skill, care, and diligence. If your client, you are beholden to your client's wishes. You can advise your client as to what you think is the best thing under the circumstances that they're dealing with. If they have the question, but if they are adamant about terminating, then you are to write up the termination agreement and have them sign it. If they're adamant about asking for a repair, you are to write up the request agreement and submit it to the other party and let the other party respond. So one of the things that you must do is obey your client's wishes. Accounting, if they ask for copies of documentation, provide them. Disclosure of information, if they ask about material fact and you find something out, you need to let them know about it. Skill, care, and diligence means you put out your best efforts to represent them as best as you can in the circumstances. And please, please, please respond to their efforts to reach out to you for information or a response. Even if you don't have a response, let them know. Communicate, communicate, communicate. It's going to keep you out of trouble more than anything else. Dual agency. I'm always amazed at how agents can be in this business as long as they've been in this business and not understand dual agency. I had an agent who'd been doing dual agency on a regular basis, had been in the business for 30 years, and always asked me if it was designated agency, if she was representing both the buyer and the seller. It's not. Designated agency, designated modifies dual agency. Dual agency is you're representing, the firm is representing both parties. Designated means you have an agent that's assigned to each of those parties. So if you have one agent representing both, that's straight dual. If you have Mary Smith and Joe Jones representing the buyer and the seller under the same firm, then that is designated. On those agency agreements, there are 3 little places for the clients to initial The first block is, do you want dual agency or exclusive agency? And if you check dual agency, then you can modify that with the next third block down. And that says, now I don't want Mary Smith to represent both me and the buyer. I want Mary Smith to represent me as designated, and y'all find one of your other agents to represent Joe on the other side. So that's how that works. The limited role of a dual agent, as I discussed earlier, is basically like a mediator. You can provide basic statistical information for them, but you cannot really advise as to, you know, what terms of an offer they should do or anything like that. You're basically filling in blanks based on information they request. And disclosure of information, once again, you can disclose material facts, which you should. However, you cannot disclose the motivation of the other party or their financial information or anything confidential from them, and you must be balanced and fair to all the parties involved. Selling a for sale by owner. If you are representing a buyer and a buyer has a for sale by owner that they would like you to go and make an offer on, you need to discuss with your buyer before you approach that seller how that commission is going to be addressed. Number one, you have to have an agency agreement with one party or the other in order to be compensated. So if you have a buyer's agency agreement, this is a good time to talk to your buyer about the fact that the buyer's agency agreement says the buyer is on the hook for the commission. And although you will approach the seller on their behalf and talk to them about paying the commission for the buyer, if they refuse to do so and the buyer wants to write the offer, then the buyer's got that responsibility to cover the commission. Alternatively, you can talk to the for sale by owner about listing the property and representing him in the sale. So either option is okay, but in order to receive compensation, you have to have representation on either the buyer side or the seller side in an agency agreement to that effect. As far as selling your own property, I've had several calls on this recently, where I have a buyer calling me up and saying they're in dual agency and the seller is the listing agent. And I'm like, that's very interesting, because that listing agent cannot represent you as the buyer in this transaction. That is against license law. If you are the seller and you are a licensee, you are required, number one, to disclose material facts. Do not use no representation on your residential property disclosure. You must fill them out to the best of your knowledge. And you cannot, must not attempt to represent the buyer in the transaction. You should give the buyer the Working with Real Estate Agents brochure, tell them they are free to get their own representative. You are to tell them you are not going to be said representative. If they want to write an offer, then they are going to either have to get a representative or go and get an attorney to draw up their offer to purchase for them, because you cannot represent them. That General Statute 93A6 is just a reminder that you can receive disciplinary action if that happens and we receive a complaint. Drafting legal documents. You are not, unless you are an attorney as well as a licensee, you are not to perform any legal services, and you are not to write legal documents. You're not to draft your own addenda. You're not to line through a contract. You're not, or to do anything like that. The only thing you are allowed to do is fill in the blanks on a pre-printed form that has been approved by the Bar Association or NC Realtors. You can't draft contracts. You can't draft addenda. If an appropriate form for the situation that you are in or dealing with, or your buyer or seller wants you to participate in, is not available, you must consult an attorney and have an attorney draft that document. The parties to the transaction can draft something, but if you get a party drafted addenda to an offer to purchase, when you present that to your seller, your next words out of your mouth should be, you need to have an attorney review this document before you sign it and ask any questions that you have to ask about how this is going to affect you and what your rights and obligations are. Had a call today about someone who had received a buyer drafted appraisal addendum that the trigger got pulled on because the appraisal came in super low, and the seller was not happy about having signed the addendum and was now saying that the addendum didn't apply anymore because he didn't like it. Well, not up to us to determine that, it's just up to us. If we'd received a complaint, we would be asking the agent, did you recommend they have an attorney review that before they signed it? So your role is to recommend that, and not to review it with them or try to interpret it. That's practicing law. But always recommend that they have someone take a look at anything other than the realtor sanctioned forms. Lack of communication is also a big issue that we get. They often complain about not hearing from their agents, not having calls returned, and not getting relevant information to what is going on. You should, as much as possible, try to document your correspondence and conversations. If you've discussed something face-to-face with a client that you think is kind of important, you might want to follow it up with an email detailing the conversation so you've got something showing this conversation took place. We require that you disclose material facts, but we don't say how you are to disclose them. So rather than saying something verbally and thinking that's adequate, once you've discussed it verbally with the client, then you should formalize that in a text message or an email or something like that, so that you've got some backup documentation to protect yourself. And clear communication is absolutely essential for a successful transaction. And like I said earlier, the more familiar you are with that offer to purchase, the more you help your client understand what their rights and obligations are and what the other party's rights and obligations are. That's communication, that's discussion at the very beginning. That also helps bring about a successful transaction, a lot fewer misunderstandings. Now I cannot read the top of my, hang on. It is okay to offer incentives to your buyer clients. However, the monies must be disclosed to a lender if there is any. And if a lender objects, you as a broker cannot then provide the incentive. Any monies that are provided to those buyer clients has to be documented on the settlement statement. And any secret loans or payments under the table or payments after closing are strictly prohibited. Wire fraud. Wire fraud is a seriously big issue right now. Fortunately, I have not gotten a lot of calls on it recently. I think the agents are finally sort of getting ahead of it a little bit and educating their clients well. NC Realtors, I believe, has information blurbs on the offer that cautions them against wire fraud as well. You need to communicate to your client that if they receive an email or you receive an email, text message, or phone call, for them to make a wire transfer, that they are then to call the closing attorney's office directly using a verified phone number and verify the wire instructions. And a verified phone number would be, you're going to Google that attorney's information and get the phone number off their official website, or you're going to give them the number that you have that you use to call the attorney, and they are not to take the number off of an email that they get and then call the attorney off of that email, because that email is probably the fraudulent one, and they've got someone who's got a number in there that will answer that and that can cause some issues. Do never forward any email or text message that you get regarding wire transfer instructions to your client. Call the attorney, call the attorney, call the attorney, have the attorney and or your client talk directly to one another for that information. Any emails received on cell phones or tablets don't always show the sender's email address. So if you have a client who needs to wire money, you and or your client should be calling that attorney directly for all of that information. And just be very, very, very careful about how you deal with it when there's wiring instructions involved. Miscellaneous issues that come up: property description and items to convey. They have altered these offers to purchase to include items now that are not necessarily fixtures, but are, maybe personal property type of items that are included. Make sure you're familiar with what the contract lists as items to convey. Discuss anything that your seller does not want to convey. When you're presenting an offer of purchase, be very thorough about checking to see what the buyer is asking for. Don't just gloss over the personal property section. I get calls on this frequently. Surround sound systems, projector systems, things like that a buyer asked for, and when the listing agent presented that seller the offer, it got overlooked, and we don't understand, and my seller doesn't want to leave it now. And we've had hot tubs, the same thing. Buyers, if you put a picture of a hot tub in the listing and the buyer doesn't ask for it, they're assuming it comes with the property. So it needs to be specified in that contract. If the buyer sees something that's personal property or that's not specifically listed that they want, or if the seller does not want something to convey, that is also addressed clearly at the time of the offer is written. Possession before recording. No, we're just going to say no to that. We know it happens all the time. Buyer possession, foreclosing. There are forms for that. We never recommend. That's just wide open for issues and complaints. If you're going to put a buyer in there before closing or seller after closing, the forms that the NC Realtor provides specifically for buyer or seller possession are to be of a very limited nature. Any holdover daily cost should be substantial enough to deter the other party from holding over for any specific length of time, but we don't encourage the use of them. They're just not a good idea. They cause a lot of problems, a lot of issues, and a lot of times the only way to deal with it is go through an eviction process, and that's never a good thing. As far as record keeping and record retention, you must turn in all documentation to your broker in charge within 3 days of execution, and you must retain records for 3 years from the last time any money changed hands or the transaction closed. In the case of working with real estate agents brochures, they should be kept for 3 years from the time they were signed, if nothing ever came of them. And if they were with a transaction, they should be kept with the records for the transaction from 3 years from when the last action was taken on it. Use the force of the brochures. I highly recommend this. We have, like I said, our publications tab is rich with a lot of information. I refer to these brochures myself all the time. I have them all here. I have questions and answers on condos and townhouses, renting residential real estate, question and answers on real estate closings, offer and acceptance, a real estate safety guide. All this information is available on our website under the publications tab. Great resources. And like I said, I mean, there's a charge if you want to order the actual brochures, but you can download a PDF copy of anything and have it for your reference and or for your clients. They're great tools, and I highly recommend using them. If you have any questions, or if you wish to follow up, you can always go to our website and find information there. Their contact numbers are on there for regulatory affairs, which is my number, and for licensed services. You can send an email to ra@ncrec.gov. That's regulatory affairs, for any questions that you might have. And now I'm going to first go back and see if I've got questions on my chat here. And let's see. Has there been any discussion of faster ways to transfer due diligence to sellers, since so many contracts are now being done digitally? Is it standard to request buyer to overnight check to seller, especially since USPS has been having lots of delays? That's negotiable between the parties. I have had agents who have discussed using Venmo. I have had agents who have said that checks have gotten lost in the mail. I do not recommend having a client stick a check in the mail. There's no way to track it. Even if you use it overnight for USPS, they don't guarantee overnight delivery. So I recommend using a guarantee type of overnight delivery, such as FedEx or UPS overnight. And it can be sent directly to the seller if they wish to do that. Anything that the lender might require or restrict should be addressed. The buyer needs to check with the lender to see if the lender has any restrictions on how to transfer earnest money or due diligence. But as long as they can track the source of it, then that's not going to be an issue.
Dee,
Yes, sir.
at a previous meeting, our understanding was that they're going to change the offer to purchase in July, that whole due diligence, how and when, and there'll be boxes, just kind of like the earnest money is.
Yeah. Well, since NC Realtors are the ones that do that and create those forms, they generally, prior to the, usually sometime mid-May or June, that time frame, they start sending out the information about the changes that they're making, and they'll have numerous meetings at the boards of realtors about changes and how they're going to affect contract negotiations. I'm not aware right now of what they have in the works. They haven't communicated that to me. But they definitely will make sure that everyone's aware of any changes that are taking place. But for right now, we are where we are.
Right.
Let's see. Clearly, the contract form does not provide for refund of the due diligence fee in the event of a material misrepresentation. However, the issue seems to be that the potential damages available to a buyer because of a material representation by the seller side would likely include the due diligence fee. It doesn't say material misrepresentation. It does not mean that there is no remedy to the buyer. It just means that that's not automatically available as a remedy. It means that the buyer will probably have to take a seller to court if they cannot negotiate some sort of settlement based on the non-representation or the misrepresentation. The contract includes the right of reinspection, correct. But most agents, wait, they don't reinspect. They go and, they wait till right before closing and do a walkthrough right before closing. So I don't recommend doing that. If you've asked for repairs, then you should exercise that right to reinspect early enough. So if something is not to your satisfaction or the buyer's satisfaction, it can be addressed prior to closing. New outer loop. Many agents are not disclosing. Not disclosing outer loop near property. Should this not be a material fact? I would say that most likely it is a material fact. You should always err on the side of disclosure. When in doubt, disclose. Disclose, disclose, disclose. We cannot go out and force them to disclose that. However, if we receive a complaint and this was something they should have known or reasonably known, then that is going to be an issue for them. let's see, when should agency agreements be signed for rentals? Well, agency agreements are usually property management agreements when it comes to rentals. The leasing side, generally, there's not usually an agency agreement between an agent and a tenant. There's an agency agreement between an agent and an owner to manage their rentals, and the tenant's agreement is the lease. Working with real estate agents, brochures do exist for rental, but they are not required. So if you choose to use those, that's up to you. They're not required, so that's another question I don't see, but I'm answering anyway. Does that answer your question, Vicki, about the agency agreements? Okay, and what if the seller, okay, good, thank you, Vicki. If the seller agent is selling a rental property that they don't know much about, or if it is a deceased family member, well, you should try to find out as much as you can. So if it is a rental property that you have an ownership in, or it's something that was inherited, we're going to leave it up to you, but you should be able to try to find out as much about it as you possibly can and fill that out. Are there any other questions? That's the last of the one on the chat.
I have a question. Well, I might have a couple of questions, but
Okay.
how many? I forget the number of, you said how many complaints there currently are or whatever, but I'm curious if there's been an increase in complaints this year.
For a little bit. Last year, I think we had 1,800 as our number when we were doing our presentations. This year it's 2,000. I think in my opinion, the due diligence issue and the multiple offer issue in the seller's market has sort of caused an increase in misunderstandings between the parties and how all that works. So, which automatically comes with an increase in complaints. Right. So yeah, I would say they have increased this year. It's but like not, the Wild West out there.
Not like 100% though, or anything.
No. Just okay. A small, probably 10, maybe 10%.
Okay. So. That's not too bad.
No.
Okay, my other question is about square footage, and this always comes up, and I have people come to me and say, well, the commission, you won't get in trouble if you're under X% of the true number. Can you say whether or not that? My understanding was the commission never gave a number. The phrase I always heard was, we don't know what too much is, but we'll know it when we see it.
I'm going to go with that too. I'm going to say, stick to the residential square footage guidelines book as much as possible. There's always a possibility that there's going to be a discrepancy between, what you choose to list as heated square footage and what an appraiser may call heated square footage. Pay attention to your below grade and your ceiling heights, that type of thing. Be as accurate as you possibly can and document what you're doing. And if you have any question, have a third party look at your calculations and make sure that they're correct. So
there's no number like, again, I've always, well,
as long as it's
under 10% or 5%.
So I'm just going to say that. I think I saw 5% somewhere in our stuff, but don't hold me to that.
Right.
Usually if it's like under 100 square feet, I think difference. I think that's kind of depending on the size of the property.
Right.
That's usually I went by, yeah.
Yeah, there's no doubt. It's a big property,
Yeah.
It can be an entire room that you're missing.
I think 5% is not an unreasonable number. And it's difficult sometimes to measure some of these spaces. You just do the best that you can, and you can always, there are appraisers out there that will, for a fee, go out and measure a property for you. And I like that idea because they know what they're going to count in their appraisal or not. So they're going to give you a measurement based on what they would give, and if they were doing an appraisal on the home. So.
But I see Roger Bernholtz's comment that he regularly sees appraiser measurements that vary significantly from one another. And I don't
Thanks
disagree.
for that, Roger.
I don't disagree with that. You send two appraisers.
Ultimately, the agent is responsible for what they represent.
Right.
And thank goodness that most MLSs now put a range anyway, so they're not specific until it closes. So, generally, but you should be in that range as much as possible accurately if you're going to represent it that way. Is there anything else?
Yeah,
go ahead, Tim.
Go ahead, Steve.
Go ahead, Tim. I don't have any questions.
I was going to say I've recently represented several checks for an out-of-town buyer. Unless I'm to hold a check in hand as I'm working with them, and then they decide to make an offer and they're heading home while the offer goes in. Usually I've asked for a day to be able to get them the check, and it's often not an issue at all. But I'm asking, is that correctly handled, or do I need it in writing, or should I be holding checks in hands that are blank until we figure out?
I would say that's negotiable between the parties. So if the buyer is saying, is it okay, seller, if I overnight this due diligence check to you once you've accepted and signed my offer to purchase, and the seller says, sure, then, that's okay. If the buyer does not ever send the check, then like I said, the seller's recourse is to make the demand. And then if they don't get the money, they can terminate unilaterally. So if you've got that situation and you've asked the listing agent if the seller's okay with that, and they say yes, all parties need to understand that, the buyer needs to understand the money's due when the seller signs the contract. So it is due. They change their mind 2 days later, they still owe that money. And the seller needs to understand, number one, the same thing, and number two, that they have a right to terminate if they don't get their money when they've asked for it.
The other key question though on this is with the multiple offers. I mean, literally a seller is sitting there with a stack of offers and checks, and then you're representing a buyer and he doesn't get accepted, and now you're required to go get the check. I mean,
you can deliver the check once you if you have the check in your hand, you can keep that check. And once you receive communication that the seller signed it, then deliver it to the listing agent.
Yeah, but 90% of them say by 5 o'clock on Sunday night or Monday. And so you're sitting there with a check, and so you have to go across town with a check to give to them in the middle of the night to give them to make the deal officially legal.
No, the deal's officially legal when they sign it.
And well, we're required to hand them the check the day of the contract.
Yes,
correct?
But that doesn't make the contract not valid.
Well, I hear you, but I'm just saying we're sitting there when we're supposed to deliver the check the day the contract is signed, and multiple offers 5 o'clock. I mean,
it's due that day. Yes. So if you have it and you can deliver it that day, okay. But if it's 11 o'clock at night, I think it would be reasonable to deliver it first thing in the morning.
But that's not the letter of the law. That's all.
Well, it says it's due, and it's up to y'all how you want to execute that. So let's see. Yes, someone's asking about escalation clauses. I would like to see the escalation clause become no longer an option. It's not an option. We don't consider that to be an option, other than the fact that it's not illegal. It's not, licensees cannot negotiate or participate in the negotiations because you are not allowed to disclose the terms of another buyer's offer. The legal staff is about to do an article on escalation clauses, as well as, what was the other one they're doing an article on? Love letters. Another one we're sending down some opinion on. So that should be in April or May's bulletin. So keep an eye out for both of those. And let's see, what about agents who won't change MLS to contingents until they have the due diligence check? Isn't that wrong? Well, that's an NC Realtor issue, not an NC Real Estate Commission issue. We don't care anything about what status is in the MLS. You can leave it active if you want to, but the existence of a contract is a material fact. So it's an MLS rule. You need to check with your board as to when you can change it. The contract is a contract when it is signed, not when the monies change hands. Someone said, I thought that the due diligence check could be withdrawn if it hadn't been given to the seller. The office has received the due diligence, but the seller hasn't yet. If the buyer calls you, buyer's agent, who has check in hand and an accepted offer to purchase, and the buyer says, give me the check back, you are to give them the check back. The seller's only recourse at that point would be to make the one-day demand and terminate, and then take the buyer to court for the payment of the due diligence fee. So you are to honor your client's desire and wishes to return the check if you are asked to. Excuse me. Sorry. Tickle. Anything else?
Is that it?
Is that it?
Okay.
Thank you for having me today. I enjoyed it. And appreciate your time.
Really appreciate it, Dee. And I don't know if Ashley or Cub or Jessica wants to say anything. I believe there's some, or Gail. Gail could say something.
I'll just say thank you. Picked up a few good nuggets.
No, it's great. Really
Yeah, I want to
appreciate
say
your time,
thank you
Dee.
to Dee as well. This was wonderful.
Thanks. I appreciate that.
And I also want to remind everybody who's on this call, tomorrow night is our awards ceremony. Make your our awards event. It's going to be great. Love to see all of you there.
And if you haven't bought a ticket yet and you don't know how, then just call me. I would help you.
Okay, well, thank you all, and get back to getting into those competitive offer situations. Good luck.
Go get them.
Thanks. Thanks, Susan.
Take care.
Thanks. Bye.
Thank-